ACRO's second webinar on the European Union's General Data Protection Regulation. I'm Julia Funaki. I will be your moderator. Let me introduce to you today to our speakers. Mark McConaughey is Vice Provost and Registrar at Indiana University Bloomington. He's also ACRO's VP for Information Technology, and until this past year was our Director for the ACRO Technology and Transfer Conference. Brett Cohen is a partner at Hogan Lovells, and he helps educational institutions with privacy, cybersecurity, internet, and consumer protection laws. He's been translating legal standards into practical technical requirements that are easy for clients to use and understand, which we will be grateful for today. Heidi Wax is a member of the Jenner & Block law firm, where she works with privacy and information governance practice. She's a nationally recognized leader on education privacy issues. We thank them all for being here, and let's get started. Our agenda today is, first we will talk about GDPR, the General Data Protection Regulation, its implementation and basic principles. Then we'll move on toward implementation, some things we need to think about. Then clarity needed, and this is going to specifically focus on territorial scope, rights, including the right to be forgotten, and the transparency items that were addressed in the NACUA webinar. We'll talk a little bit about risk assessment as well as a breach reporting guide, and then we'll move into and spend a good deal of time on some sample situations. With that, Brett?
Thank you, Julia. So I'm going to start out the presentation with some background information on GDPR, just a level set, and for those of you who've listened to this on NACU or some other forums before may find some familiarity in this, but it's good to go back to the foundations, and we hope that by going through some of the hypotheticals later on, it will help you apply these a little more concretely in the ways that you will in your day-to-day. So one thing I think is important to level set is that the GDPR, this new European privacy law that is overriding the existing Data Protection Directive in Europe. Really, in Europe, privacy is treated as a fundamental right. And so it's not as privacy law we think of in the United States, where there are, we have laws that apply to specific sectors, such as FERPA applying to education information, or PII and education records that we think are worthy of additional protection. Under this law, all personal data is covered, and the protection of personal data is treated as a fundamental right. So this is with respect to both students and employees and donors, and a large category of information that we'll talk about in a little bit. The second piece that's really important that is different than U.S. law is there has to be a lawful basis for all data processing under the GDPR. This means that you can't just collect all and any information that you want with the expectation that you might use it for some useful purpose later. You have to have a lawful basis for using the information, and we'll touch on this in a little bit, but some examples are, and you may have heard these before, consent of the individual when necessary to perform a contract, when required by law, although be careful, that means when required by EU or EU member state law, or a topic you might become well acquainted with when it's in the legitimate interest of the institution as balanced against the impact on individuals. Another component of the GDPR is that personal data processing is subject to particular principles, and I'll get into that on the next slide, so I won't dwell on it here. And then finally, there are specific rules for processing special categories of personal data, which you may have heard as sensitive data, which are personal data, as you can see on the screen, concerning racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetics or biometrics, health, sex life or sexual orientation, or criminal record information. And I'm fairly certain based on what you do that you have at least some of these. And the special rules that apply to this information are essentially as a baseline requirement. You'll only be able to collect these when required by law or when you have consent, and we'll talk about what that means in a little bit as well. So the principles approach, and I'll put these up on the screen, I want to talk about. These are a number of principles that are required under EU law, and they're very intangible. You'll understand what they mean, and there are some analogs to existing principles that that institutions have to comply with, or as part of your mission comply with. But it's interesting, under EU law they are expressly codified. So just to run through these quickly. Institutions and other organizations that are subject to the GDPR, and again we'll talk again a little bit about what information is subject to the GDPR, have to process personal data lawfully, fairly, and in a transparent manner in relation to the individual. The principle of purpose limitation: personal data must be collected for specified, explicit, and legitimate purposes and not further processed in a manner that's incompatible with those purposes, meaning that the purposes for which you collect and use information have to be disclosed up front. Data minimization. So this is a legal requirement. Information must be kept adequate, relevant, and limited to what is necessary in relation to those stated purposes for which they are processed and collected. Accuracy. Information must be accurate. Personal data must be accurate and, where necessary, kept up to date, and reasonable steps must be taken to ensure that personal data that are inaccurate are corrected or deleted. Storage limitation. Personal data must be kept in a form which permits identification of individuals for no longer than is necessary for the purposes for which their personal data are processed. Security. Personal data must be kept secure. This is a broad mandate for security of all personal data, regardless of its sensitivity. And accountability, which is a new principle under the GDPR as compared to previous European law. And we'll talk about this in a bit, and this is going to be the overarching theme of our presentation, and what your compliance with GDPR will look like is that you really need to take steps that demonstrate that you are putting in place appropriate controls, appropriate administrative, technical, physical controls to protect personal data against misuse or a violation of any of these basic principles or of a security breach.
So Brett,
I'll turn it over to Mark really quickly. Yeah, please go, Mark.
Well, no, and I was basically going to interrupt. Really given a broad set of principles here, and I know you're going to talk about some provisions later on in the session here, where we talk about the various rights of the individuals, whether it be consent or the right to be forgotten and those kinds of things. Are we running into a mission collision here in such a manner in which, as a registrar, my principal mission is to collect and maintain records about the students' academic performance within our institutions? I have to maintain a clear and concise and complete record in order to maintain my primary objective within the institution. Is that running into conflict with the set of provisions here that are being propagated at the GDPR?
I don't think so. I think really the GDPR supplements a number of those. Certainly, if you look at it strictly from a FERPA perspective, there's the access and correction obligations under FERPA, and then for your missions to keep information accurate and up to date, this certainly complies with and dovetails with that principle. But it goes even broader than that, and individuals are given very specific rights with respect to their information, which, even though consistent with your mission, you may not have experience dealing with those very specific types of rights and requests, such as those you mentioned, the right to be forgotten, which we'll talk about a little later in the presentation. So I think it's something where your mindset will be in the right place and you'll be aligned with the individuals who have these rights under European law in some respect, and in other respects you're going to have to put in place procedures to deal with those specific rights when they are exercised.
Understood. Thanks.
So moving on, this is we previously discussed something very intangible, and now let's talk about how this might impact a university. And so that is my long-arm jurisdiction joke up on the screen. You have the European Union reaching out and grabbing us. How does this impact university? There are a few jurisdictional prongs that we'll talk about in a little bit. But essentially, the law applies to those who are on the ground in the EU and to those who offer goods and services to the EU, and goods and services being interpreted broadly as offering something to a individual or to a consumer in the EU. So that could be offering the opportunity to apply for a job, for a position at a university. So there are a number of broad ways that I've identified here about how this might impact a university. You'll see where U.S. universities who have their own branch campus or study center in the EU, U.S. universities sending students to or at local counterparts such as exchange and research or other internship programs, collaborations with EU institutions. Online learning programs are a big one where you have global users, including those in the EU. Research that incorporates EU data sets where there's a transfer of EU data to the U.S. You may have dealt with this under existing European privacy law. Soliciting student applications from the EU, which will obviously have a big impact on you all, and we'll talk through some hypos on that later. And then recruiting faculty from the EU and receiving donations from the EU, or a couple others that will apply where we are either on the ground in the EU or we are offering goods and services to the EU. So just to take a step back and just to examine the comprehensiveness of the GDPR's approach, it applies to all processing of personal data, and I've put the definitions of those terms up on the screen, but I'm not going to read them because essentially it's extremely broad. Personal data is anything that relates to a person. This can include not only your standard database information, but also information that's tied to a student's device identifiers or computers or IP addresses. So anything where you're using to track an individual user, that is covered by the definition of personal data. Processing is any operation or set of operations. I think you can avoid the definition of processing because it basically means anything you're doing. So if you're storing it, you're touching, that's processing personal data. And this is, as I mentioned before, very different than the approach under U.S. law where we only talk about PII, which is it's identifiable information in an education record about students. Here we're talking about any personal information that you maintain, which includes, again, of employees, of students, of vendors, and so forth.
And that would include attributes like grades and so forth, correct, Brett?
Yes, it would include anything, any piece of data, any field that is included in a record with otherwise personally identifiable or personal data. So if you can imagine, anything in the student record is going to be considered personal data so long as it's tied to the individual. This slide covers, the beginning of it covers what I already mentioned, the organizational prongs. The third prong, the jurisdictional prongs. The third one that I didn't mention is that it applies to the monitoring of behavior of EU residents, and that's most relevant in the context of the use of cookies and online tracking remotely over the internet, which may be applicable to some institutions, particularly with respect to websites and distance learning initiatives. But that's the third prong of the jurisdictional test. Another higher level concept that's important to understand, which I'll cover in a little more detail, is that the GDPR and European privacy law more broadly applies to two different categories of entities. One are controllers and one are processors. Controllers, I'll talk about that in the next slide about the importance of the distinction. But essentially, as the last bullet points out here, this encompasses any time that you're working with EU residents. So just to talk about the broad scope: applicants and families, current and past applicants, alumni, scholars, staff, researchers, and anyone involved in institutional exchange. More on the concept of controllers and processors. And again, on the fundamentals of this, there are different obligations under the GDPR and under European privacy law, even existing European privacy law, tied to whether you are a controller or processor of personal data. And we're going to explore some of this in some of the hypos later. But the controller is the entity that determines the purposes and means of processing of personal data. So I think of that usually as the data owner, although not exclusively and always, and then the processor is an entity that processes personal data only on behalf of and on the instructions of the controller, and I think of that more so as a pure service provider. To make things more confusing, you can be both a controller and a processor at the same time, and for different purposes, and there are different sets of legal obligations with respect to either. Controllers are the types of organizations that have to justify their processing under a lawful basis. You have it a little easier as a processor, given that you can defer completely to the role or the instructions of the controller. So let me give you an example of how that might work. Is if you're doing a research project in collaboration with a European institution, and really you're only taking data sets, you're performing some sort of function on it, and you're delivering the results back to the European institution, and you don't have any right to use the information for your own purposes. You'll be a processor for the use of that information, and then as a result you won't have the obligation to obtain consents or informed consents where required, because ultimately it's not done for your benefit. That said, a new feature under the GDPR as compared to existing European privacy law, whereas under existing European privacy law, processors are not directly regulated. They are merely subject to contractual flow-down provisions. Under the GDPR, there are some direct legal obligations on processors, most notably maintaining data security, which is going to be a concern of everyone now that there's new data breach notification requirements, which we'll also talk about. But processors are subject to fewer obligations than controllers, but one where you're starting to go through your data sets and what you collect, it'll be important to determine when you're a controller and when you're a processor.
And
so
Brett,
with that, I will, oh yeah.
Before you leave that, just to be real clear, you know, in the world that we live in, higher ed institutions, often our student information systems, for which registrars are often the primary administrator. In your definitions here, we're the ones collecting the information and basically performing all of the operations necessary in order to maintain that data. We, therefore, are the controllers. Would that be a good interpretation of that definition?
Yeah, that's right. And so the way that this will interface with you in your role is that you'll have to consider one, all of the controller obligations, but two, when you're dealing with third parties and you're disclosing information to them, you'll also have to make a determination about whether they're a controller or a processor, and that will dictate what contract provisions are required by European law to include in your agreements with those third parties, which is another wonderful new implication of what you're doing under the GDPR. You might have to update your contracts with vendors and other third parties you're sharing information with, so you'll want to develop operating procedures for that.
And just to make it real for us, you know, for us, if we're the controllers and we have entered into a contract with somebody like the Student Clearinghouse, who is providing a certification of our students on our behalf, or perhaps we're dealing with a learning management system who is providing those kinds of services for the institution's behalf. They become the processors in this particular paradigm, correct?
That's right. If they're purely accessing the information for to provide the service to you and not for their own purposes. That is a question of law that you'll have to determine on a case-by-case basis. But yes, in those circumstances where they're providing a service to you, and that's something you'll want to specify clearly in your agreement with them, then they'll be your processor, and there are certain specific legal obligations when you're working with processors to flow down particular contractual requirements.
Great. Thanks, Brett.
And this is Heidi. I just want to chime in a little bit and make just one quick point there. One thing to keep in mind is that it's not the registrar per se who is the controller, it's the institution as a whole who is the controller. The designation of a controller or a processor happens at the overall entity level and the organizational level, not at an individual business department level or for an individual, him or herself.
Yeah,
very, very good point.
Okay, so this is Heidi. I'm going to take the reins now, and we're going to talk a little bit about consent, but also sort of on the broader topic about when can you process personal data under the GDPR. Another point that I'd like to make, which is probably going to be a little bit frustrating for all of you, but I assure you it's equally frustrating for us as well trying to advise on these matters, is that the GDPR has not come into effect yet. That doesn't happen until May 2018. And therefore, there's still a general lack of clarity about what a lot of these provisions will mean in operation. To further complicate that, there are carve-outs in the GDPR where the member states themselves have been provided or delegated the authority to step in and write additional regulations on top of the GDPR. And so what we're talking about today and what we're setting is a very broad framework of what's required under the GDPR, but over time we will continue to get additional clarity about what is actually required under it and what it actually looks like in operation. Slowly, over the last couple of months and next few months, the Article 29 Working Party, which is a group of data protection commissioners, has been issuing guidance and advice on pieces of the puzzle, but we're still not sure what the whole big picture will actually look like in practice. So just to give that background as I delve into now a little bit more of the operational aspects of how the GDPR is going to work. So in order to, yep.
Oh, no, go ahead. Well, I was just, this lawful processing of personal data, and you were going to get into the whole idea of consent. Are there divisions here where, on an ongoing operational basis, I need to collect a certain amount of information about our students, collect what grades they've received in their courses, whether or not they're enrolled. All of those things happen on a very routine basis. I assume I have to have a broad consent platform to enable me to operate on that general basis or general set of principles or operations. Is there a framework I can use to determine when the general consent works and when I need special consent on behalf of this group of EU students in order to continue doing what I do? If that question makes sense.
So the question makes sense, but I think actually it would be helpful to take a step back from that and go a little bit broader. So in order to process data and to further confuse the lingo and the vocabulary, as a controller, you are still processing data, right? You don't need a processor to be processing data. The controller can do the processing itself. So as a controller, you are collecting personal data and you are processing it to perform certain business functions as required by your business needs or at the request of the data subject, the person who provides you their personal data. And in order to process personal data under the GDPR, you need a legal basis to do that. And the GDPR lists out a number of what these legal bases are. And so some of those bases you can do without obtaining direct consent, right? So you need consent or it's when it's necessary to do these things. So the sub-bullets on this slide. if it's necessary to perform or enter into a contract, if it's necessary to comply with a legal obligation. So these things are when actually you don't also need explicit consent unless, to further complicate things, you are also collecting sensitive data, in which case you also need consent. So there will be times where you will want to obtain consent, but we'll get into this a little bit more later. It's important to also remember that consent can be revoked. So if, for example, an applicant who's living in the EU agrees to provide you with their information and clicks consent, and you create a valid consent structure, they can also revoke consent at any point, at which point the institution needs to cease processing their data. So I understand this is like very complicated and very confusing, but it's sort of the Wild West about how all of this is going to actually operationalize, but that is what the GDPR states is required. So when you rely on consent, further to your question, Mark, and to your point, Mark, there are bounds around what that consent must look like. So the consent requires to be valid, clear, affirmative, and demonstrable action. So no use of pre-checked boxes. You have to actually ask them to do something, to check an unchecked box, to show that they have provided affirmative, demonstrable action to give that consent. And the data controller, so the institution, has to also retain a record regarding how and when the consent was provided. So what at the time, if consent is provided in May 2018, somewhere there should be a screenshot or a capture of what that consent template looked like at the time consent was given, and that students 1, 2, and 3 consented at that time. If you change what the web interface looks like and when the consent is collected, say in August 2018, because you've decided to tweak the interface and make some changes, you will now need a record that students 4, 5, and 6 accepted under that image and what that consent looked like. So, just to keep that in mind, consent cannot be permanently binding. You can't say that consent exists forever and ever. The data subject must be given the right to revoke the consent or withdraw the consent at any time and must be informed of this right in that interface where consent is first obtained. You cannot condition the performance of a contract when not necessary to perform the contract. You cannot condition the consent on that. And any request for consent must be presented clearly and in plain language distinguishable from other matters. So you can't collect blanket consent if there are multiple operations that are going to be happening under the consent. So, for example, you wouldn't want to collect consent to application process and other purposes, so application and financial aid and 2 other things. You would want to say, I'm consenting to the application process, and then if there was something else, you'd want them to also consent to the something else separately and distinctively.
Heidi, I want to add also one important point is while we think of consent in the U.S. as a sort of a cure-all, we can do what we want with information once we get consent. Consent is only one of the bases for lawful processing, as was mentioned on the earlier slide. You can see there are a number of different ones, and in fact, given all of these very intricate conditions that come with consent, and particularly the ability to be revoked. In many cases, we're looking at other bases for processing under the law. So in particular, whether if it's necessary to engage in the relationship, such as handling grades for students who are enrolled, that's certainly necessary to maintain the relationship with the student for the purposes for which they're attending your institution. So you don't need to get consent for them to do to collect and maintain that type of information for them, but it does require you to go through and think about what your basis for processing will be for everything, and where you do have to rely on consent. You'll have to tick those boxes, no pun intended, but consent is not always going to be required. Just to put that down.
Right, and I think I may be a little ahead of the game, but as you said that, so Heidi mentioned, they have the right to take back their consent. So in the so in the idea that I'm collecting grades and all of a sudden I realize I'm not doing so well in my class, I don't think I'm going to let the registrar collect the grades in this class. That's what you mean by they really don't have that much of a right to take away that operational process because it's the lawful practice of what we've agreed what we're doing. Is that correct?
Yes, I think that's the point that Brett was making. I don't want to speak for him or put words in his mouth, but I think that's the point that Brett was making.
Okay,
yep.
Great.
So another part of GDPR is that you have to provide notice. There's a right of the data subject to be informed about the data processing and why the personal data is being collected in the first place. And so there's also specific provisions under the GDPR about what that notice must include. So for example, the notice here must include the identity and contact information for the controller's representative or data protection officer. In other words, if somebody has provided you with their personal data and they want to make contact with you for questions or additional information, who is the person who they can contact to get responses for those answers to those questions? What is the purpose of and the legal basis for the processing? So again, back to Brett's point, if the basis of the processing is one of the legitimate interests where consent is also not required, that should be made explicit and clear in the privacy notice that is provided to the data subject at the time the data is collected. Should also make clear what the categories of personal data that are being collected are, who the recipients or the categories of recipients of the data will be, the source of the personal data, that needs to be disclosed when the data is not obtained directly from the individual. So most of the times, an institution of higher education is going to be in this middle column where data is obtained directly from an individual. But when data is not obtained directly from the individual, if, for example, in Mark's example, you're getting information from the student clearinghouse, then that would fall into the right-hand column of the notice that you would need to provide when the data is not obtained directly from the individual. Other points that must be included in the notice, whether the data will be transferred to third countries and what safeguards are in place or what controls are in place to protect the data when it's transferred to a third country. Another point to keep in mind here, when we talk about data transfer under the GDPR, it doesn't actually mean that the data needs to physically move from the EU to the US or to another jurisdiction. If somebody in the US has access rights and can log in to data that is stored on EU people in the EU, that in and of itself is considered a transfer. That access alone, even though the data never moved or left the jurisdiction, is considered a transfer. The retention period, so how long the data is retained, the existence of data subjects' rights, so that the data subjects have these rights to exercise, their right to withdraw consent, which was mentioned earlier, the right to submit a complaint to the regulatory authority, the consequences for failing to provide certain data or types of data, and whether or not you are engaging in automated decision-making. So what's your homework? The homework on the notice front is to review your website privacy policies and any notices that are provided to applicants, whether those are applicants for admission or applicants for jobs with the institution, and to modify them where necessary to address the items that I just reviewed, to identify which data is collected directly from the data subject versus which data is collected from other sources, to ensure that notice is given at the appropriate time, and to ensure that the third parties who supply you with data provide timely notice to them so that you can in turn provide timely notice to the individuals where necessary. So that the downstream provision of notice is happening as well. So that's sort of your homework and your takeaway on this and what needs to be done. So there's also an additional right for data subjects under the GDPR called the right to be forgotten. And as Julia alluded to earlier, you may have heard about this a little bit before. The right to be forgotten is the right for data subjects to make a request that you delete or destroy the records that you have about them, including those containing personal data. And so it's not an absolute right. There are cases where it does not ride out overall, but the right to forgotten will be very case specific for the type of work that registrars do, and we're already anticipating some tension between the GDPR and this right to be forgotten, especially, for example, state schools who have state-mandated retention periods under state FOIA laws or other requirements. And so in those cases, we have to wait a little bit and see a little bit more about how, about what the guidance is that's provided on the right to be forgotten and how it plays out. Okay, still me. Data breach notification, another issue that has come up quite a bit. So I think this is also a good point to take a step back and explain that a lot of what's being required under the GDPR, or at least the framework to get yourself ready for the GDPR, involves things like conducting a data inventory, understanding your data flows, understanding who has access to what data and where that data is stored. And these things are generally considered best practices from a data privacy and information governance perspective in general. They are issues that organizations such as EDUCAUSE have been discussing and promoting within higher ed for quite some time. And so if this is sort of the boost that higher ed needs to begin to identify those pieces of the puzzle and get a better handle on its data and information governance practices, that's going to help overall comply with a lot of other issues, including in the U.S., not even getting to the GDPR. And so, for example, data breach notification is one of those. In the past, the U.S. has been hyper-focused on data breach notification requirements. And the EU did not have a data breach notification requirement, or at least not as explicitly as we have under the 48 state data breach notification laws in the U.S. And so now, under the GDPR, the EU is introducing data breach notification requirements. And the GDPR defines breach as defined in this first bullet here, a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data. Just for the sake of comparison, under the U.S. state laws, they largely say something along the lines of when personal information has been subject to unauthorized access or unauthorized acquisition. So the requirement under the GDPR is that if you experience a breach under this definition, and that breach is likely to result in a risk to individual rights and freedoms, the supervisory authority, so the Data Protection Authority, must be notified within 72 hours unless law enforcement has been engaged and they have requested a delay in notifying the supervisory authority because they believe that such notification will impede the law enforcement activities. Notification to individuals is likely if it will result in a high risk to individual rights and freedoms, and that must be done without undue delay. So not the same as the notification to the supervisory authority. You have a little bit more leeway in understanding what the time frame is for undue delay. Again, to sort of compare and contrast that with the current U.S. model, some states have notification timelines, but some states also have language that says something to the effect of promptly. And the supervisory authority may instruct the data controller to provide notification to individuals once they've been notified, except where it's unlikely to result in a high risk or an appropriate technical and organizational protection was in place, such as encryption. So if it's encrypted data that was subject to the breach and it can't be decrypted, or notification would involve disproportionate efforts. So those are some things to take away and keep in mind. It's very important, again, in general, best practice, and it will be very important once the GDPR comes into effect, for institutions in general to have data breach and incident response plans and processes and procedures for when an incident or a data breach does happen. So again, if there is a data breach, you must notify, if you're a processor, you must notify the data controller about all breaches. We're waiting for guidelines on that and what that will really look like without undue delay after becoming aware of the breach. The information in the breach notification must include the nature of the records and the approximate number and categories of individuals affected, the contact information for the applicable data protection officer or other point of contact, the potential consequences and likely consequences of the breach, and the measures that are being taken to mitigate the breach. Data controllers must document the incident and create a record of the facts related to the breach, its effects, and what remediation steps were taken. And non-compliance with the breach notification portion of the GDPR comes along with fines of up to 10 million euros or 2% of annual global turnover, whichever is higher.
So just to let you know the overall risk assessment, so I know that the overall concern is to what extent does the GDPR affect us as higher ed institutions? What steps must we take? What are the consequences if we fail to take those compliance steps? What all has to happen? And so as we, I went too far. When we take a look at risk assessment, ACRO has taken the steps of pulling a group together, the members of the group to basically analyze GDPR and to see what kinds of best practices we can put together, at least in the form of guidance for our membership, includes folks from ACRO, folks from CASE, EDUCAUSE, Hogan Lovellis. You can read those yourself, but basically a lot of the higher ed professional association as well as some professional guidance, quite frankly, from those we've heard from in the webinar today, to really provide a deliverable in terms of how to proceed appropriately once the GDPR guidelines take effect. So that's really what ACRO is doing in the short term in order to address these things. But we would like to take all of the fine information we just heard from Heidi and Brett and try and put those into really a lens that is more appropriate for the kinds of business that we perform on a daily basis. And as a result, just take a look at some sample situations and get our guests' view on how they really apply. So in the first situation, sample situation 1, let's talk about admissions and territoriality and which groups actually constitute a group that becomes under our guardianship and administration and then forces us to become compliant with the GDPR regulations. First of all, I think it's an obvious one that if we're collecting application information for our specific institutions, and of course it's going to have personal identifiable information, and we're doing this for students within the EU, I believe that's a no-brainer. All of a sudden, we have information in our repositories that force us to take action. Brett, Heidi, is that true?
Yes. If the processing is occurring on the basis of or in the context of on-the-ground operations in Europe, it will apply regardless of the nationality of the individual.
Right. And if we're accepting applications from EU citizens, but we are territorially within the United States, I believe it applies to those citizens as well, correct?
That's correct. Under the prong of we're offering a service to these individuals. This is this is one of the broadening of the jurisdictional provisions of European law that occurred with the GDPR. You all are unfortunately caught in the crossfire between some regulatory debates between online services and the European regulators who included this jurisdictional provision to try and include some of these popular online services. But to the extent that you are offering applications to residents of the EU to become students, then that would be covered with respect to their application information.
So, and just to drill on that a little bit further, so I'm accepting applications, and some applications we accept, some we deny. For those we deny, do we still carry those compliance responsibilities?
If you collect the information, then you are subject to the requirements of the GDPR.
Okay, and then I imagine I have to pay attention to my residency requirements. In other words, how long I'm going to keep the data before I purge it. I'm still responsible for notifying and gaining their consent in order to deal with their application information, correct?
Correct.
And then, and this is one I admit I didn't sort of share this right before the webinar, but let's say that, now I've got an application from an application from an EU citizen. I accept them. They travel to the United States. They now live in the United States or are a resident of the United States and consuming our services territorially within the U.S. Because they emanated from the EU, am I still required to be compliant with these regulations, or am I now more subject to the U.S. regulations as a result of delivering the service here?
So this is where it gets very messy and very complicated, because in theory, data that continues to be collected from them while they're here is not subject to the GDPR. In theory, right? None of this has been tested or enforced or anything like that yet. But in theory, data that is collected from them at the time they are in the U.S. is not subject to the GDPR, only data that is collected from them when they're in the EU. But as a practical matter, I would imagine it's very difficult, depending on the SIS you're using, to separate those pieces of information out and say, well, now this record is no longer subject to that, but the previously collected data is still subject to GDPR.
Yeah,
I got you. Go ahead,
Brad. This is the fundamental question for you all as registrars, which is, what do we do? Is the entirety of the student record, to the extent that we've got an applicant from Europe, is now continuing to be subject to the GDPR? Is this a continuation of the service that we've provided? And as Heidi alluded to at the beginning of the presentation, these are areas. This is a completely new jurisdictional clause, and in my experience, certainly whenever a regulator is given broader jurisdiction, they test the limits of that jurisdiction. So the question that we've been helping our clients answer is, to what extent do we separate out this information? Do we make arguments that we can treat certain information as covered and not covered? I think one of the most important things to think about when talking about compliance, and we haven't mentioned it yet, is I want to include two pieces of information. One is that there are really high maximum fines under this law. You may have heard it. There's some discussion in the chat window, as high as 4% of global annual revenues. But we don't expect those to be imposed as a matter of course, so long as you are taking reasonable steps to comply. Really, and to go to the second point that I wanted to make, is one of the major concerns of the legislators and the regulators in the EU about information privacy is they really want organizations to be compliant and to take steps towards compliance. And so given the significant uncertainty and ambiguity in the obligations, what we're advising our clients to do is take a look at what might be considered in scope, draw reasonable conclusions about what is and is not in scope, and then be flexible, pay attention to the developments in the law, and if you did get a knock on the door, if you did get a complaint, then if you have a reasonable compliance plan that's rooted in a reasonable interpretation of this new requirement, the historical enforcement practice in Europe is not to drop a maximum fine on an organization immediately that's looking to comply. So I think that's one thing. What you're doing now, being on this webinar, taking steps to build an accountability program and a privacy compliance program, building on your existing programs to account for this information will go a long way to mitigating a lot of the more significant risk.
I think I might be beating a bit of a dead horse, but would it be possible, so in the scenario we just described, where I kind of separate out the information that I've collected while they were on EU soil and the information that I've collected here territorially, can I then, through a notify and consent process, basically say, hey, look, because now most of your information is collected here territorially in the U.S., and even though we've got a little bit, please give us your consent so that we no longer have to be compliant with these GDPR regulations for your record. Now, is that a reasonable thing?
So I would like to hear Brett's opinion on this too, but in general, you can't ask people to waive legal rights.
There you go. Okay.
Yeah, that's correct.
All
That's, U.S. or otherwise. In general, you can't ask somebody to say, to waive a legal right that they're granted.
Right. So and the idea was just trying to segregate the two and then say, well, give me permission. That way I don't have to do the segregation.
Right.
Yeah. Gotcha. Sort of moving along to sample situation number 2. So I understand that we have an institution where our current domestic students are attending a branch in the EU. Is there a difference in how that data is handled? Since they are territorially within the EU, can we assume that all of those students are subject to the same rules and regs?
So again, the data that's again, the data that is collected from them while they are in the EU, they are entitled to all of the rights for data subjects under the GDPR.
Okay. And
I will.
Go ahead.
I'll add to that. There are 3 main ways where risk is going to pop up here. One is complaints. So currently enforcement is very complaints driven. If an individual and students are known to complain about things if they have individual rights or something's not going the right way. But complaints are the first vector of risk here. And that's something to consider whether you have a significant number of European students or U.S. students that are visiting Europe. That's the first main way. The second is data breaches, because now we have data breach notification. So to the extent that you're obligated to notify a breach to a regulator in Europe, they will become aware of it, and that could induce them to investigate. And the third is anything big that sort of hits the news, which is sort of the wild card where they feel like they have to act. So I would consider all of your operations in light of those 3 main ways of risks manifesting, and that's a good way of gauging. Even though some of your operations and a number of your operations in all of those categories I mentioned at the beginning of the presentation are subject or could be subject to the GDPR, ways about how you prioritize your risk and what you do to comply should be informed by those areas of how risks might manifest.
Gotcha. And to turn this on its head a little bit, and you had mentioned this a bit earlier in the webinar. So what about students who are consuming our services online? They're territorially within the EU. However, the services are emanating from here in the U.S. My assumption is all of those students we must serve those students in a compliant manner with the GDPR.
That's correct. As long as you are collecting data from EU residents, that data is subject to the GDPR.
Okay. So moving along to the third situation, and this really is about sort of universal consent. You know, we ask our students as they enter into an admissions process, and actually, quite frankly, each term in which they register, we ask them to agree to our terms of service before they proceed. So the real question right there is that sufficient? Is that sufficient for GDPR? In other words, they know what they're getting into, we know what services we provide, and is that a reasonable compliance effort from the point of view of the GDPR?
So if you are...
Oh, go ahead.
Go ahead, Brett. No, go ahead, Brett.
No, I was just going to say for many websites, presenting a privacy policy is going to be sufficient, except, again, going back to our lawful bases of processing, where you need consent in order to handle or process personal data. And so if you do have a website that is subject to the GDPR, and that's a question that you should be thinking about separately, but if it is subject to the GDPR, your task will be to determine when you have to rely on consent. Where you don't, just presenting a privacy policy and getting acknowledgement or agreement to the privacy policy should be fine, but where consent is necessary, then you'll need the unchecked checkbox that Heidi referred to earlier in her presentation.
And you'll want to make sure that the privacy policy that you present incorporates the elements that are required under GDPR for notice. So if you're relying on a lawful basis other than consent, you'll want to make sure to state that in the privacy policy.
Yeah, so it does appear to me, and I think I'm stating an obvious thing, is that the lawful basis and what constitutes lawful basis and what requires additional consent and potential revocation becomes a big thing. And establishing those guidelines, and one of you mentioned that a bit earlier, is there relevant guidance for determining what the bounds of lawful basis are?
It's trickling out, and we're waiting to see more.
The upshot of a lot of this is, given the relative lack of guidance, we are advising to try and justify the processing of data as much as possible on anything other than consent, given that consent is relatively inefficient for wide-scale, repeatable data use, right? If someone opts out, you'll have to, or doesn't consent, you'll have to comply with that. They can revoke their consent, and if you want to treat all of your students equally, then consent is very difficult to use. There are some things where you will need consent for under various EU rules. So certain direct marketing, to go to your second bullet point on this slide, the placement of cookies requires consent, although that's interpreted currently under European law by most European regulators to be a banner that you click on. So if you've ever accessed the internet while you're in Europe, very likely you'll see a banner that says, "We're placing cookies. Do you accept this? Click here." But other than some fairly well-defined scenarios, another one is the use of sensitive personal data, and we went over those categories before, which requires, as a baseline rule, requires consent. Other than some of those, if you can justify your processing on other grounds other than requiring a check-the-box, separately set-aside consent, then most of our clients are trying to take the position that they can do that.
Yeah, thank you. That's a difficult one. I assume this has to do with the IT ability to track the movement of the user. So yeah, thank you for that one. Moving on to situation number 4. IT handles these sorts of issues. Is there any reason us business folks, as functional folks, should be too concerned?
I mean, I would make the argument that the business people have the better idea of where and what data is collected and why it's needed. So the business people are really critical for creating this data mapping of which processing activities the institution is engaged in and what data is collected for each of those processing activities, so that then you can detail what is the legal basis for those processing activities, each of those processing activities. IT may know where the data is going, but they may not know the why.
Gotcha. And going to the last, and in the interest of time, I think I'll combine all of these into, really, these are all questions about the right not to be forgotten. And in general, I think there's an overall concern, specifically as you read through that provision, that there is an ability on the part of the individual to boutique their record. In other words, if they have things that are associated with bad things that either they've done, they didn't accomplish, they owe money, there may be various things that are associated with the records that we keep that they wish not to have affect them in the future, or to wish that we disclose or even keep. So the general question is, to what extent does this right to be forgotten extend into the individual repositories that we maintain?
So this, again, I think is an area that we're going to see play out in terms of what this really means, to see some operational evidence of what it means to comply under this provision of GDPR. But I do think, again, it's important to remember that it's not an absolute right. And under the article of the GDPR that lays out the right to be forgotten, there are carve-outs for when you're not obligated to delete data. Unfortunately, they oftentimes align with legal obligations or requirements under EU or member state law. But I think that these types of scenarios like debt collection and things like that, to Brett's point earlier about having a framework and justifying why you're making the decisions that you're making, will fall under that.
Yeah, I think...
I'm sorry, go ahead.
Oh, I was just going to say, I think the way to operate here and the best way to prepare is to sit and say to yourselves, okay, if we get one of these requests to delete all of this information, what position are we going to take? Based on the legal standard, based on the exceptions to deleting information, and based on the information that students or individuals are required to provide in order to make a deletion request. And so how we help our clients through this is we sit down and say, okay, first off, let's determine what you have, what your basis for processing it is, which is something you're required to do. And then if we get a deletion request, let's create a standardized process that's based on a reasonable interpretation of the legal requirement that we can then apply in a particular situation, so we're prepared for this, so we're not reliant too heavily on an individual case-by-case basis to make determinations. And so, unfortunately, we can't walk you through all the scenarios now. I think the important takeaway is that if a student gets academically dismissed, they can't automatically request that all of their records be deleted. For example, one of the reasons that you can retain information is to defend against legal claims. And so there are arguments to be made about you retaining the information for a statute of limitations period. But that goes into the whole mix of complying with accountability obligations. So determining what information you collect, how long you keep it, what's a justifiable period. And once you have all of that organized from a data governance perspective, making some of these decisions about how to comply with these individual rights requests fall into place. So we're sort of talking about it in the abstract here, but once you start to go through the exercise, you see how the pieces fit together a little better.
It seems to me that the large... I'm sorry, go ahead.
Just one quick thing that I was going to say is that, where possible, I know it's very cliche to say, but I'm a big fan of not reinventing the wheel. And so where possible, I would look to analogous processes and procedures that you may already have in place to fulfill the requirements of the GDPR. It's not 100% net new for institutions to think about. So for example, one of the rights of the data subjects that we didn't really delve into is there's a right to access the information that somebody has on file on you and make amendments and rectify information that's incorrect. Now, a very, very simple example of that, perhaps oversimplified, is how do you deal with requests to change names when somebody gets married or divorced? So you already probably have a process in place where somebody can contact you and say, I'd like to update my file and my official record to make my new last name this. So to think about how to sort of take that as an example and scale it up to what the requirements of the GDPR are.
Right. Yeah, and I was thinking about it in terms, I think it appears to me naively to have a large overlap with the lawful basis argument. In other words, we have certain things that we're required to do in order to maintain the repository of information we're charged with, and part of that is maintaining a full and complete record of academic performance per se, or from our own perspective, a complete financial accounting of how we dealt with particular individuals. And as a result, we need to play those things so that they're internally consistent and creating a practice for which is easy to explain and is rational. That's what, at least that's how I'm interpreting the responses. So I recognize that we're running a bit over, at least in terms of an hour. I know we can run a bit over, and it's now probably time to deal with some of the questions that have come in. And for that, I'll turn it over to Julia.
All right, thank you, Mark. We do have many questions that are coming in, and they're great questions. And we want to really pay attention to those. So what we're going to do, what we've decided to do, is we're going to post an FAQ of these questions and then answers to them onto our website. So look to the ACRO website for that information. But let's just go through a couple of them. There seemed to be a recurring question that went something like this. How can EU law be enforced for an American college with no physical holdings in the EU? And are any of their penalties actually enforceable to U.S. institutions?
So, I mean, that's a great question. And I mean, the answer is just as our laws in the U.S. grant the U.S. government long-arm jurisdiction over the activities of foreign third parties that are directed to the United States, that's essentially what the GDPR is doing with its jurisdictional provisions. But the question pointed out some really good practical limitations on their ability to enforce and collect. That hasn't stopped the European authorities from doing so in circumstances where they have seen a very keen interest to act, again, primarily in the context of U.S.-based consumer-facing online companies that may be operating out of their headquarters in the United States. But if they're sufficiently motivated, they may make that decision to move. But I think in the end, I think we need to inject a bit of common sense into all of this, and to see if a regulator that has relatively limited resources, is going to be significantly motivated to investigate a U.S. university with no physical presence in Europe. It would probably take something fairly major for them to do so, or a significant number of complaints, or something that hit the news. So that's the way that I would think about it.
Anything to add, Heidi?
No, that's what I would have said.
Okay. I had a question about the fines. It was mentioned the 10 million euros and 2%, but elsewhere we have heard that it's actually 20 million euros and 4%. Can you explain that difference between the two?
Yeah, there are just, and I don't, unfortunately, can't list the laundry list off the top of my head, but different articles under the GDPR are subject to different fine structures. So violations of certain articles are subject to 10 million and 2%, and violations of other articles are subject to 20 million and 4%.
Another question just asking for an example of a legitimate record that can be forgotten.
So I would argue that if you are collecting applicant data but the students are not admitted, that would seem to me to be the type of record that an EU person could make a legitimate request under the right to be forgotten about.
Okay, thank you.
Yeah. The right to be forgotten will apply differently in the context of different types of information, but the situation where it will apply the most is where you're handling information that's not necessary, strictly necessary for your provision of employment or educational services to an individual. Let's say for donors, you're collecting information about donors based on their various interactions. And so in those circumstances where the university is using the information, let's say it's for its legitimate interests, then at that point what you would do is how the right to be forgotten applies in that circumstance is that it has to be balanced against the legitimate interest of the university to maintain the information has to be balanced against the individual's stated reason for wanting their information to be forgotten. That's where we apply all of those principles that I talked about earlier, relevance, completeness, all of these really wishy-washy and mushy concepts that are difficult to apply. So now we get to apply a balancing test, which also creates uncertainty in application. But those are the types of circumstances when the right to be forgotten most likely will be imposed, and it'll be a little clearer in the other circumstances.
Okay, thank you. And we're going to take one more question. And I think this is a pretty broad one, but how does Brexit impact GDPR?
The UK has made clear its intent to be subject to the GDPR even in the aftermath of Brexit.
Okay. Once again, we will post many of these questions and replies and maintain it on our website. Please check back for when that's available. And let's see here. Also, we have selected resources that you can look to, and we will be running one more webinar. Okay, and also we will send an email to let you know when the questions are up and available to our ACRO membership. So finally, that last slide, we will have another webinar on GDPR, at least one more. That is slated at this point for January of 2018. We also have all of our webinars archived on our website, including the first GDPR webinar. I'd like to take this opportunity to thank our presenters very much, Mark, Heidi, and Brett. You have really helped to delve into this issue and to begin to bring some recognition and clarity to what it is we have in front of us. So I thank you, and we hope you join us again.